The next topic is judiciary, alternative dispute resolution. Recently, SC has launched online mediation training web portal. So this is current affairs, लेकिन उससे जुड़ा हुआ हमें देखना है जो static है. It is developed collaboratively by NALSA and Mediation and Conciliation Project Committee. MCPC was constituted by Supreme Court of India in 2005 to oversee effective implementation of mediation and conciliation in country. It provides comprehensive training in mediation to legal professionals across country and promotes alternative dispute resolution mechanisms. ADR is a process in which disputes are addressed and settled outside courtroom. It offers to resolve all types of matters including civil, commercial, industrial and uses neutral third party to communicate and resolve dispute. Types क्या क्या होता है? पहला होता है arbitration. Arbitration में a neutral arbitrator renders a decision called award after there has been presentation of evidence. तो यहाँ पे एक neutral arbitrator होता है. Mediation में it is a flexible process that can be effectively used at any time during the course of dispute. तो ये कभी भी यूज़ कर सकते हैं, भले आपका केस चल गया हो या तभी. Conciliation में क्या होता है? Neutral third party to communicate with parties in exchange of information and settlement options. Negotiation traditionally occurs directly between parties. मतलब इसमें कोई third party involved नहीं रहती है and their counsel and does not involve neutral third party. Collaborative law, both parties are represented by a collaborative attorney and both parties agree not to litigate. तो ये 1, 2, 3, 4, 5 टाइप्स होते हैं. एग्जिस्टिंग फ्रेमवर्क्स डोमेस्टिक में क्या है? आर्बिट्रेशन एंड कंसिलिएशन एक्ट ऑफ 1996 एज पर यूनिसिट्रॉल मॉडल लॉ applicable to all kinds of arbitration including commercial disputes. Act has been amended in years of 2015, 19, 21. Arbitration and Conciliation Amendment Act of 2021 allows for an unconditional stay of enforcement of arbitral award in cases where arbitration agreement, contracts or award itself were obtained through fraud or corruption. This amendment was effective retrospectively from October 23rd, 2015. New Delhi International Arbitration Center Act of 2019 for facilitating institutional arbitration. Indian Council of Arbitration or Society registered under Society Registration Act of 1860. ग्लोबल में क्या क्या चाहते हैं? इंटरनेशनल कोर्ट ऑफ आर्बिट्रेशन विच वॉज established in 1923 by International Chamber of Commerce. Permanent Court of Arbitration established by Convention for Pacific Settlement of International Disputes in 1899 at Hague. India is also party to this. Unicitral model law of international commercial mediation and international settlement of agreements. Then comes the Mediation Act of 2023. President of India granted assent to passed Mediation Act of 2023 seeking to promote mediation as a preferred model of ADR in India. मीडिएशन को बढ़ावा देंगे, मतलब ये 5 मेथड में से मीडिएशन को बढ़ावा देने के लिए एक्ट अलग से डिफाइंस मीडिएशन जो एक्ट है. इट इंक्लूड्स एक्सप्रेशन मीडिएशन, प्री लिटिगेशन मीडिएशन, ऑनलाइन मीडिएशन, कम्युनिटी मीडिएशन. Parties attempt to reach an amicable settlement of their disputes with assistance of a third party referred to as mediator. Voluntary pre-litigation mediation. Parties can attempt to settle civil or commercial disputes by mediation before approaching any court or certain tribunal. Disputes not fit for mediation relating to claims against minors or persons of unsound mind involving criminal prosecution affecting the rights of third party. Territorial jurisdiction. Mediation to take place within territorial jurisdiction of court or tribunal of competent authority unless parties agree otherwise or undertake mediation in online mode. Timeline for conducting mediation must be completed within 120 days. मतलब कि 4 months नहीं 4 months नहीं, हाँ 4 months में, which may be extended by another 60 days with consent of parties. Party may withdraw from mediation after 2 sessions. Court annexed mediation must be conducted as per the rules framed by Supreme Court or High Courts. Establishment of Mediation Council of India. 1 chairperson, 2 full-time members with experience in mediation or ADR, 1 part-time member including law secretary, expenditure secretary and 3 ex officio members. Defines mediation service providers as a body or organization recognized by MCI for conducting mediation. Mediation can be done by authority constituted under Legal Services Authority Act also. The enforceability agreement resulting from mediation will be binding and enforceable in same manner as court judgment. Verdict can be challenged before a competent court within 90 days. Mediated settlement can be challenged on grounds of fraud, corruption, impersonation, and disputes not fit for mediation. Lok Adalats. Supreme Court organized special Lok Adalat on 75th year of its establishment for dispute settlement. About Lok Adalat, that is People's Court, one of the ADR mechanism got statutory status under Legal Services Authorities Act of 1987. 2002 में the act was amended to establish permanent Lok Adalats for public utility services which are guided by principles of natural justice. Powers: they are not bound by Code of Civil Procedure 1908 and BSA 2023. It has same powers as that of civil court, and decision made by Lok Adalat is final, binding and no appeal can be made. तो ये कुछ डिफरेंसेस है लोक अदालत और ग्राम न्यायालय में. मीनिंग क्या होता है? ADR रिजोल्यूशन मैकेनिज्म टू सेटल केसेस आउटसाइड रेगुलर कोर्ट. ग्राम न्यायालय में होता है विलेज लेवल कोर्ट्स स्टैब्लिश्ड अंडर ग्राम न्यायालय Act of 2008 for speedy justice in rural areas. No fixed territorial jurisdiction can be organized at district, state or national level. Operates at the panchayat level with jurisdiction over specific rural areas. Civil, family, labor, land dispute, minor criminal cases. Civil cases, land, tenancy, property, wages and criminal cases of petty nature. Established under Legal Services Authority Act of 1987 और इसका अलग से 2008 का एक्ट है. Judicial authority chaired by sitting or retired judicial officer, judge or magistrate, presided over by a न्यायाधिकारी, a first class judicial magistrate. Conciliatory focuses on mutual settlement between parties. Semi-judicial functions like a regular court but with simpler procedures. Binding nature: decision is binding if both parties agree. No appeal is allowed. Decisions are appealable in regular courts. Fee structure: no court fees, informal setting, nominal fee applies, making it accessible for rural people. Reducing backlog in courts and provide quick amicable dispute resolution. Brings justice closer to rural areas and make it affordable. Key differences क्या हो जाएंगे? लोक अदालत are settlements courts where both parties must agree. They resolve cases quickly with no appeals. Gram Nyayalayas function like village courts with a magistrate, follow judicial procedures and allow appeal. But दोनों का purpose is like same only. फिर आता है हमारा cases referred to लोक अदालत include cases pending before any court, any dispute which not have been brought before any court and is likely to be filed before court. Now, nature of cases undertaken includes matrimonial disputes, property disputes, motor accident claims, land acquisition, etc. First Lok Adalat was held in 1982 in Junagadh, Gujarat, which was successful. उसके बाद से सारा और भी इसके लेके एक्ट बनाया गया. Free legal aid. Supreme Court issued directions of LSS to ensure access to free legal aid for prison inmates. It refers to provision of free legal services to individuals who are unable to afford legal representation or access to justice system. Legal aid can include legal advice, representation in court proceedings, mediation, negotiation, and alternative dispute resolution mechanism. Constitution provisions में Article 21 एंड 39A जो कि एक DPSP है जिसको 42nd CAA से ऐड किया गया था 1976 में. Statutory provisions: LSA Act of 1987 which came into force in 1995 to constitute LSAs to provide free and competent legal services to weaker sections of society. National Legal Services Authority (NALSA), State Legal Services Authority and DLSAs were accordingly constituted. Section 341 of BNSS of 2023, legal aid to accused at state expense in certain cases where accused lacks the means for legal engagement. Government steps taken for legal aid, designing innovative solution for holistic access to justice in India, Disha scheme, Telelaw, Nyaya Mitra program, Lok Adalat, etc. NALSA, statutory body under LSA Act 1987, provide free and competent legal services to weaker sections of society, formulate policies, principles, guidelines, and frame effective schemes for LSAs to implement legal service program throughout country. Monitor and evaluate implementation of legal aid programs. Organize Lok Adalats for amicable settlement of disputes. Eligibility क्या है? Women, children, members of SC/ST, industrial workmen, victim of mass disaster, violence, flood, etc. Mentally ill people, disabled persons in custody in protective home, juvenile home, psychiatric hospital, victims of trafficking in human beings or beggar as referred to in Article 23. Persons whose annual income is less than amount prescribed by respective state government in case if the case is before court other than SC, and less than rupees 5 lakh if the case is before SC. Tribunal system in India. Allahabad High Court held that appeal against an order of Central Administrative Tribunal while exercising contempt jurisdiction under Administrative Tribunals Act of 1985 lies before Supreme Court and not High Courts. Tribunal system in India. Quasi-judicial bodies to reduce caseload of judiciary and bring subjective expertise for technical matters. Article 323A and Article 323B. CAT was established under Article 323A. Jurisdiction, adjudication of disputes and complaints with respect to recruitment and condition of services of persons appointed by public services and posts in connection with affairs of union or other authorities under control of government. 2010 Supreme Court clarifies that subject matters under Article 323B are not exclusive and legislatures are empowered to create tribunals on any subject matter under their purview as specified in 7th schedule. Each tribunal is given specific jurisdiction to hear and decide cases within designated area of expertise. Some tribunals have appellate jurisdiction, meaning they hear appeals from decisions made by lower authorities or government bodies. Appeals from tribunals usually lie with concerned High Court. However, some laws specify that appeals will be heard by Supreme Court. Difference between tribunals and courts. Established by Act of Parliament. So they are basically statutory and this is by Constitution, and the tribunals were recommended by Swaran Singh Committee. Purpose is to resolve disputes and complaints on specific matters, and the courts are to interpret and maintain law and order in their jurisdiction and give decisions on civil and criminal matters. Procedural compliance, not bound by specific procedures but governed by principles of natural justice, bound by procedural codes. Members, a mix of judicial and experts with specific knowledge. The members are in courts are judicial only. Powers limited to law under which they are all set. Powers to use all enacted laws before making a decision. Bail. Recently, a two-judge bench of Supreme Court of India in this particular case ruled that bail is the rule and jail is an exception, even in special statutes like UAP 1967. Court observed that denying bail in deserving cases is violation of rights under Article 221. Legal provisions of bail in bailable offences. Section 479 of BNSS. Maximum period for which an under trial person can be detained is 1/2 of maximum period of imprisonment. मतलब कि जिस क्राइम के लिए उसको अक्यूज़ बनाया गया है, जो चार्ज्ड है उस पर, उसका जितना क्राइम का जो सज़ा है उसके अगर हाफ कंप्लीट कर लिया तो फिर बेल मिलेगी. First time offenders will be given bail if detained for over 1/3 of the maximum period of imprisonment. Special laws such as POCSO Act, Protection of Women from Domestic Violence Act, etc. also contain provisions related to grant of bail. Forms of bail: regular bail, granted to persons already arrested and in police custody. Anticipatory bail, precautionary bail is granted before arrest for a non-bailable offence. Interim bail, temporary bail is granted before hearing for regular or anticipatory bail. Default bail granted when police failed to file a charge sheet within prescribed period. Measures taken for bail. Plea bargaining enables pre-trial negotiation between defendant and prosecution. Section 290 of BNSS, plea bargaining has been made time-bound and application can be made within 30 days from the date of framing of charges. Applies only to offences punishable up to 7 years of imprisonment with further restrictions excluding cases involving crimes against women, children, socio-economic offences. E-prison software facilitates state authorities to access data of inmates in efficient manner. Related news, 2-judge bench of Supreme Court held that bar on anticipatory bail under Section 18 of SC/ST Act of 1989 is not applicable unless prima facie case under Act is made out against accused. Section 18 states that Section 438 of CRPC, which provides for anticipatory bail, shall not apply in relation to cases involving offences under the Act. Section 482 contains relevant provisions for anticipatory bail. SC/ST Act of 1989 to prevent commission of offences against SC/ST, Special Code for trial of such offences, and provision for relief and rehabilitation of victims. Salient features: accused must not be a member of SC/ST. Offences include employing members of SC/ST in manual scavenging, dedicating SC/ST women to deity, temple, etc. It also provides for punishment for neglect of duties under Act by public servants not being a member of SC/ST. Gram Nyayalayas. Supreme Court raised concern regarding the feasibility of setting up Gram Nyayalay as mandated by the Act. Key features: ensuring the opportunity for securing justice are not denied to any citizen, and this is backed by Act, that is, it is statutory in nature. Act exempts states of Nagaland, Arunachal Pradesh, Sikkim, and tribal areas specified in the Act. Seat of Gram Nyayalay is located at the headquarters of the intermediate Panchayat. Status: it is deemed to be court of judicial magistrate of first class. State government appoints Nyayadhikari for each Nyayalaya in consultation with the High Court. It is a mobile court with both civil and criminal jurisdiction to settle petty disputes at village level. Dispute process: disputes are to be settled with the help of conciliation between parties, and these are not bound by rules of Indian Evidence Act, etc., but by principles of natural justice. Appeals in criminal cases lies to Court of Sessions, and civil cases lie with the district court and shall be disposed within 6 months from the date of filing of appeal. So there पे time limit दिया हुआ है. Contempt of court: Jharkhand government has filed a contempt petition against the centre alleging delay in appointment of Chief Justice of the High Court. It is defined under Contempt of Court Act of 1971. Article 129 and Article 215 give power to Supreme Court and High Courts to punish for contempt. There are two types. First is civil, which is willful disobedience to any judgment, decree, direction, order, writ, or other processes of court, or willful breach of an undertaking given to a court. Criminal contempt is publication of any matter which scandalizes or lowers the authority of any court, prejudices or interferes with due course of judicial proceedings, or interferes with or obstructs the administration of justice. Mercy petition: President has rejected the mercy petition of a terrorist, and the constitutional provisions related to this are: Article 72 empowers the President to grant pardons, reprieve, respite, suspend, remit, commute the sentence of a person convicted of any offence where sentence is by court-martial, for offences against any law relating to matter to which executive power of union extends, or sentence of death. Supreme Court quashed arbitral award against Delhi Metro Rail Corporation. What is curative petition? It is last constitutional remedy available to a person whose review petition under Article 137 has been dismissed by Supreme Court. Given shape in Rupa Ashok Hurra versus Ashok Hurra case, and curative power of the court flows from Article 142, power to do complete justice. Curative petition is entitled if petitioner established that violation of principle of natural justice, judges fail to disclose his connection with the subject matter, there is an apprehension of bias and judgment adversely affecting the petitioner. Fast track special courts are much more efficient in handling rape cases and those relating to POCSO Act, according to report released by Indian Child Protection. It is centrally sponsored scheme launched in 2019, extended up to 2026. Funding center bears its expenditure from Nirbhaya Fund. Implemented by Department of Justice, Ministry of Law and Justice. Objective is to ensure swift disposal of rape cases and those coming under POCSO Act. 755 FTSCs out of decided 1023, including 410 exclusive POCSO courts, are functional in 30 states and UTs. These are linked to National Justice Data Grid. Zero FIR case against a former minister for allegedly making objectionable comments against the Telangana Chief Minister. It refers to FIR that is registered irrespective of the area where the offence is committed. Once registered, it is transferred to appropriate police station for investigation. No regular FIR number is provided initially. The relevant police station registers a new FIR for investigation. The provision is under Section 531 of BNSS based on Justice Verma Committee's recommendation, which was established in aftermath of 2012 Nirbhaya case. Doctrine of coverture. Supreme Court is to hear petition challenging the MRA under Section 375 and Section 63 of IPC and BNSS respectively. What is doctrine of coverture? Legal doctrine under English common law that places married women under the cover of a husband, treating them as a single entity. It suspends the very being or legal existence of women after marriage. In theory, it seeks to pass on her property to the husband, restricting her ability to hold property, enter into contract, etc. Doctrine of harmonious construction. While refusing to condone the delay, Supreme Court laid down principles to provide harmonious construction to Section 3 and 5 of Implementation Act of 1963. Notion of condonation of delay encompasses discretionary power of court to extend prescribed time limit for filing an appeal application. What is doctrine of harmonious construction? It means that in case of conflict between two laws, their interpretation should be in way in which spirit of and essence of both the laws are maintained, which is done by harmonizing the laws. The origin is traced back to First Amendment made in judgment of Shankari Prasad versus Union of India.